Hey, welcome back to this week's legal tip. As the notorious BIG used to say, mo money, mo problems. And that's what we're seeing now with this earnest money. Earnest money is a complete disaster. I told the real estate commission when I tried the case that established the problems with earnest money that it was going to be a problem. And here's yet another problem we're seeing. So don't know that it'll ever get fixed by the commission, but we got other problems we got to deal with. So what happens now? As you know, most of your brokerages are not holding earnest money. Quite frankly, I'm not sure I would hold it either if I was a brokerage. So that earnest money duty has been passed over to the lawyer. So what happens though is you sign a contract today with your client, and then you send the contract, or you sign the contract saying you send it over to the seller saying we have a contract that we'd like to present, and in the contract it says $500 to be held by Blair Cato. The problem is you don't have the check. The seller accepts the contract, sends it back, you ratify it, and you got a contract. Somewhere around Friday or maybe next week, the contract gets sent to our office. Still, there's no earnest money because your buyer was supposed to come down to our office and deliver us the check. Apparently, they never get here because they get busy, whatnot, life gets in the way. And lo and behold, 2 weeks passes, your buyer decides to default on the contract, seller wants the earnest money, but there's no earnest money to be had because it never got to the law firm to hold. Now they look back at the contract and say, you as the agent represented when you presented the contract that you had the earnest money and you didn't. So they want you to pay it, or they're going to file a grievance against you. Starting to see this happen more and more. So there's a couple ways we can handle that. Number one is in the contract 4A, write 0 for earnest money to be presented with the offer, $500 under paragraph 4B to be delivered within 5 days of ratification to Blair Cato. Once you get the ratified contract, I would email back the seller's agent and say, hey, we got the contract ratified. I do not have the earnest money to Blair Cato. They have 5 days in which to send it under the contract. You are to assume that it has not been there until I tell you otherwise. That way it covers you for not making a representation that's not true. The other way to do it is have your clients write the check at the time you sign the contract to Blair Cato and have them send the check, or you get the check and have it sent yourself to our firm or to the lawyer who's doing the earnest money, and do it that way. That way you know you have it. Now the third option is hopefully in the next week or so we're getting ready to unveil a program where you can have the contract and the check signed at the same time, and then you can take a picture with this program on your phone and it will automatically send it to us in a deposit. So that'll be really cool. We'll show you how to do that in a couple of weeks, hopefully. So anyway, be very careful with earnest money. If you're not, you can find yourself getting in more trouble with the real estate commission than you want to be in, because again, this real estate commission ruling a year and a half ago that basically got the real estate brokerages out of holding earnest money is continuing to cause issues, just as I predicted. All right. Hope that helps you. Don't forget to sign up for MCE and CE classes. I think we have 2 days left. The link down below allows you to get there and sign up, and hope you all have a great day. We'll send more legal tips out.